These 10 guns could now be illegal in some states after the Supreme Court ruling that came down in April 2026. And most gun owners have absolutely no idea this happened. That is the surface level of what I need to tell you right now. And by the time you finish watching this video, you are going to understand why that ignorance is dangerous and what you need to do about it immediately. The Supreme Court issued a major ruling in April 2026, and the consequences are already reaching gun stores, firing ranges, and the homes of law-abiding gun owners across this country in ways that most people never saw coming.
If you own a firearm, if you carry one for personal protection, if you purchased one at any point in the last 5 years, this ruling has the potential to affect you in ways you probably have not even begun to consider. And here is what makes this situation particularly significant and particularly urgent. The decision came down with a degree of judicial agreement that is extremely rare in Second Amendment cases. That level of agreement at the highest court in the land is what gives this ruling its teeth and what makes it so consequential for people who did not see it coming.
This ruling applies to every state that has certain types of provisions in its public safety statutes. And right now, that means millions of gun owners across the country could be holding firearms that are classified differently under state law than they were just 6 months ago. The category your firearm sits in determines the rules that apply to it. Registration requirements, storage requirements, transport rules, and in some cases, the obligation to surrender the weapon entirely. Most people caught a headline about this ruling and moved on with their day because the news cycle swallowed it in 48 hours and moved on to something else. The outlets and voices that should be walking you through what this actually means for your rights, for your safe, for your carry setup, have largely stayed quiet or gotten the story wrong.
You clicked on this video, which tells me something important about you. You want to know what actually happened and what it means for your rights in practical, real-world terms. That is exactly what we are going to walk through right now. If you are someone who takes your Second Amendment rights seriously, who wants to stay ahead of what the courts are doing to your ability to own and carry firearms, and who refuses to be blindsided by legal changes that the mainstream media covers for one day and then forgets about, this channel was built for exactly that purpose. Hit subscribe right now, and let me prove to you that every video we put out is worth your time. Now, let me walk you through what actually happened, because the details matter far more than headlines in a ruling like this one.
In April 2026, the Supreme Court issued its decision in the case of Whitmore versus the state of California, with the ruling handed down on the 23rd of that month. The level of agreement among the justices was striking, particularly for a case touching on firearms, which has historically been one of the most contested areas of constitutional law. The case centered on a specific and important question. Do state governments have the authority to reclassify certain semi-automatic firearms as prohibited or restricted weapons without requiring a specific new act of the legislature? The court answered, yes. States can do that within the structure of existing public safety laws. And critically, the ruling did not limit itself to California. It applies to any state with similar statutes already on its books. What the court upheld is something called the Elevated Threat Classification System.
This is a legal framework that allows state attorneys general to petition a state court to reclassify a firearm when evidence demonstrates that the firearm has been used in a statistically significant number of violent crimes within a defined period, typically 3 years. And here is the distinction that matters enormously, and that most people in the conversation about this ruling are missing or blurring. This is not a ban. A reclassification is legally and practically different from a ban. When a firearm is reclassified, it does not disappear from existence. What changes is the regulatory category it sits in, and that category change triggers new rules. Different registration requirements, different storage obligations, different rules around transportation. And in some cases, a requirement to surrender the weapon if the owner does not comply with the new classification rules within a specified window of time.
The court held that this process is constitutional because it does not eliminate the fundamental right to own firearms. It adjusts which firearms fall under which set of rules. Now, before I walk you through the specific categories of firearms that are caught up in this ruling, I need you to understand something important about how this situation developed and why so many gun owners are behind the curve on it. The ruling itself was nearly 240 pages long. Almost nobody read it. Cable news covered it for a single day and then pivoted to 3 other stories that were competing for airtime that week. The publications and channels that typically cover Second Amendment issues were primarily focused on a different case that was moving through the federal courts at the same time.
So here we are, months after the ruling came down, and the majority of gun owners have no realistic awareness that their state might already be in the process of implementing the reclassification framework that this ruling put on firm constitutional ground.
Now, before I get into the list of categories that are affected, I want to hear from you directly. Does this ruling feel to you like a reasonable attempt to balance public safety considerations with the constitutional right to own firearms? Or does it feel like the Supreme Court just handed state governments an open-ended tool to keep reclassifying weapons indefinitely with no clear stopping point? Drop your answer in the comments below. I read every single comment, and this community's perspective on questions like that genuinely shapes the content we create. And while you are down there, hit the like button on this video. That signal tells the platform to show this to more people who need the information.
Here is what most people are completely missing about how this reclassification process actually works. And this is the part that determines whether you have time to act or whether the clock has already run out on you. The reclassification process is not automatic, and it is not simultaneous across all states. For the framework to be applied in a specific state, the state's attorney general must file a petition with a state court, and that court must review and approve the petition before any reclassification goes into effect. That procedural requirement is important because it means the timeline varies dramatically from state to state. Some states are already well into that process right now, potentially weeks or days away from a final reclassification order. Other states have not yet begun. The difference between those two situations for a gun owner in each of those states is enormous, and knowing which situation applies to your state is one of the most important things you can do with the information in this video.
Let me walk you through the 10 categories of firearms that can now be reclassified under this ruling. And I want you to think about this not abstractly, but in terms of what you own and what you carry. The first category involves certain semi-automatic pistols that were originally designed for military or law enforcement use, and later adapted and released to civilian markets. These are not machine guns. Machine guns are already regulated under a completely separate and much older legal framework. The firearms we are talking about in this first category are semi-automatic handguns that share specific design elements with their military progenitors.
Specifically, the court pointed to pistols with threaded barrels configured to accept suppressors that accept high-capacity magazines originally manufactured under military contracts, and that have frame designs copied directly from military specifications rather than adapted independently for civilian use. The court said these specific features are relevant when analyzing whether a firearm fits the elevated threat classification profile because they indicate a design lineage that connects the weapon to military applications that civilian markets were never the primary intended destination for.
The second category covers certain models of semi-automatic rifles that have been modified with adjustable stocks, pistol grips, and muzzle devices that were not part of the original military configuration of the base firearm. This is where the analysis starts to get complicated in ways that directly affect everyday gun owners, because the ruling does not target the base rifle itself. It creates a framework under which state attorneys general can argue that specific aftermarket configurations of a rifle push it into a different regulatory category. If you own one of these rifles in its original factory configuration, your situation may be entirely different from someone who purchased the same model and then added specific aftermarket components that the reclassification framework is designed to evaluate. This means two people owning the same base firearm could have different legal situations depending entirely on what they have done to it.
You are not going to hear the level of detail I am about to give you on cable news. They cover the headline and move on to the next story. This channel covers what the ruling actually does to your daily life, your safe, your carry setup, and your rights as they exist in the real world.
If that level of depth and specificity matters to you, subscribe right now and make sure the bell is turned on so you get notified every time we release something. The third category is where things become genuinely uncomfortable for a significant number of gun owners who have never thought of themselves as owning anything close to a restricted firearm. It involves certain magazine-fed shotguns that use a tubular or box magazine system and are chambered for shells above 12 gauge. Before you dismiss this because you think it does not apply to you, understand that we are not talking about standard hunting shotguns that have been a staple of American homes for generations. The shotguns in this category are semi-automatic models that were designed for tactical applications, that accept detachable magazines holding more than 5 rounds, and that have barrel lengths under 18 inches.
The court's ruling specifically analyzed statistical evidence about the use of firearms fitting this description in mass casualty events over the preceding 3-year period, and that evidence was sufficient to bring them within the elevated threat classification framework. If you have a shotgun of this configuration currently stored in your home, your state may already be moving through the petition process to reclassify it.
The fourth category is the one that has Second Amendment advocates most deeply concerned about the long-term trajectory of this ruling. And it is concerned not because of the specific firearms it captures today, but because of the legal precedent it establishes for tomorrow. This category involves firearms with a combination of features where each individual feature might not independently trigger reclassification, but where the combination of those features together pushes the firearm into what the court called an elevated threat profile. The reason this matters so much beyond the immediate practical impact is that it sets a legal precedent for treating feature combinations as distinct regulatory items.
If you have a rifle that meets feature criterion A and criterion B independently, and you add a magazine or attachment that satisfies criterion C, the entire assembled configuration can potentially be classified differently than any one of its components would be in isolation. Legal analysts are describing this as the firearm equivalent of being flagged for a specific loadout, where no single element was banned, but the combination crosses a line that the framework was specifically designed to identify. The fifth category surprises people when they first hear about it, because it captures some of the most popular and most widely owned firearms currently on the market.
This category applies to certain semi-automatic firearms that share a parts compatibility relationship with military-grade weapons to such a degree that parts can be transferred between them without any modification or gunsmithing. The important distinction here is that this category is not about the original design of the firearm or about how it looks. It is about the aftermarket ecosystem that developed around it. If a firearm can accept components that were manufactured specifically for military contract weapons, and those components function in the civilian firearm without any alteration, the court said that creates a legally meaningful distinction between that firearm and one that shares only cosmetic or superficial similarities with a military weapon.
The court named this principle the parts lineage doctrine, and it is going to be one of the most contested and most consequential concepts to emerge from this ruling as lower courts begin applying it to specific cases in the months ahead. The sixth category addresses something that many gun owners have invested in without ever thinking it could create legal complications for them. It covers firearms that have been equipped with certain types of trigger mechanisms that are designed to allow for a rate of fire faster than standard semi-automatic operation. Binary triggers, bump fire stocks, and other devices that the ruling specifically identifies as mechanisms designed to change the fundamental operational character of a semi-automatic firearm are all included in this category.
The court's reasoning here is that if a device is specifically designed to increase the effective rate of fire of a semi-automatic weapon to something that functionally approaches fully automatic fire, then that device and the firearm it is installed in can be evaluated together as a single, integrated, regulated item, rather than as a firearm and a separate, unrelated accessory. If you currently have any of these trigger systems installed on any firearm you own, the question of whether your state is treating that entire configuration as potentially subject to reclassification is one you need to answer now rather than later. The seventh category is the one that is getting the least attention in public discussions of this ruling, but that has the potential to affect more gun owners than almost any other single category.
This category involves certain types of ammunition feeding systems, specifically magazines and other feeding devices, that were originally designed for use in fully automatic military weapons, and that were subsequently adapted and sold on the civilian market for use in semi-automatic firearms. What makes this category especially significant is the specific legal move the court made in authorizing states to apply it. The ruling says that these feeding devices can be reclassified as independently regulated items, completely separate from any evaluation of the firearm they are used with. This means your firearm might not be reclassified at all, but the magazines you are using with it might be. The legal situation for your firearm and your magazines could be completely different from each other, and the burden falls on you to understand the distinction.
The eighth category involves certain pistol caliber carbines that are designed to accept the same magazines as specific semi-automatic pistols that are themselves either military-derived or parts-compatible with military weapons. The connection here is the shared magazine platform, which the court said creates a meaningful regulatory relationship between the two firearms, because it means modifications to one part of the ecosystem can affect the other. If you own a pistol caliber carbine that was selected specifically because it uses the same magazines as your handgun for logistical convenience, you now potentially have two firearms whose regulatory status is linked to each other in ways that did not exist before this ruling. The ninth category addresses suppressors and the firearms they are attached to in a new way that goes beyond the existing National Firearms Act framework that already governs suppressors.
The ruling says that when a firearm has been designed from the factory with features specifically optimized for suppressor use, including integrated suppressor-ready threading, ported barrels designed to work with specific suppressor systems, and stocks configured for use with suppressors, the combination of those features can push the base firearm into an elevated threat classification evaluation, independent of any NFA considerations. This is a new layer of regulatory analysis on top of the federal framework that already exists for suppressor ownership.
The 10th category is one that affects a specific type of gun owner who may not have been paying close attention to this ruling at all because they did not think it applied to them. This category covers certain competition shooting firearms that were originally designed for practical shooting sports, but that share design elements, trigger characteristics, or parts compatibility with the firearms in other categories on this list. The court's reasoning was that the application for which a firearm was designed does not insulate it from an elevated threat classification evaluation if it otherwise fits the analytical framework. If you own a competition pistol or rifle that shares the relevant design lineage, parts compatibility, or modification profile with the firearms in other categories, that competition firearm is not automatically exempt from reclassification consideration.
The people watching this right now are the ones who are going to be prepared when the legal landscape in their state shifts. That is the community this channel is building. And being part of it means you are ahead of this when most people are still catching up. Subscribe and turn on the bell so you get every notification as new developments come out of the courts and the state capitals.
Now let me talk about what this looks like in your actual life, because legal categories and court doctrines only matter when they connect to something you are experiencing or could experience in the near future. Imagine you walk into the gun store you have been going to for years, next month, and you ask about a specific model you have been considering adding to your collection. The owner tells you that your state just completed the reclassification petition process, and that model is now in a restricted category. You cannot purchase it under the new rules. And if you had owned one already before the reclassification went into effect, you would have had a 90-day window to either register it under the new rules or surrender it to law enforcement.
If that 90-day window has passed before you found out about the reclassification, you now possess a firearm that is illegal under state law, not because you did anything intentionally wrong, but because you did not know the clock was running. The penalties for unlawful possession of a reclassified firearm are not minor administrative fines. They carry real criminal consequences in most states.
Now imagine a different scenario. You modify a rifle you own with an aftermarket trigger system because you read good reviews about it, and you think it will improve your accuracy at the range. You purchase it legally, install it yourself over a weekend, and take it out for some enjoyable range time. What you did not know when you made that purchase is that under the sixth category of firearms affected by this ruling, the trigger system you installed has potentially changed the regulatory classification of your entire firearm. What was a perfectly legal rifle before the installation is now a firearm that your state's attorney general can include in a reclassification petition. Your legal range trip has created a legal liability you did not sign up for. Now consider a third scenario that I think is the most instructive of all, because it affects people who genuinely did everything right by any reasonable standard.
You buy a magazine for a firearm you have owned for years. The magazine was manufactured for a military contract weapon, but has been sold legally on the civilian market. And you purchased it from a licensed dealer without any red flags at any point in the transaction. Under the seventh category in this ruling, your state can now reclassify that magazine as an independently prohibited item. Your firearm may remain perfectly legal, but the magazine you are using with it may now be in a prohibited category.
And the legal responsibility to know the difference between those two situations falls on you, not on the dealer who sold it to you. Before and after this ruling, the landscape changed in ways that are not theoretical. Before the ruling, you could purchase certain firearms, modify them with aftermarket components, and use military surplus or military-compatible magazines without any of those individual choices independently triggering a reclassification evaluation. After this ruling, each one of those choices can be evaluated as a separate potential basis for applying the elevated threat classification framework. The rules of the game changed, and if your understanding of your legal situation has not been updated to reflect that change, you are the one who bears the cost of the gap. Now let me address the misinformation that is circulating in gun owner communities about this ruling, because you are going to encounter it, and you need to know how to identify it. The first thing you are going to hear is that this ruling bans firearms outright, and that you need to panic and act immediately without thinking. That characterization is wrong, and the people spreading it are either misinformed or have an agenda that is not aligned with giving you accurate information. The ruling does not ban any firearm. It establishes and constitutionally validates a framework for reclassifying certain firearms into different regulatory categories with different rules attached to them. A reclassification and a ban are legally and practically distinct things, and knowing the difference is essential to understanding your actual situation and responding to it rationally and effectively. The second piece of misinformation is that this only applies to California and a handful of states with historically strict gun regulations. That is false and dangerously so.
The ruling was grounded in the constitutional framework of public safety laws, and those laws exist in every single state in the country. The elevated threat classification framework applies to any state with statutes that meet the structural requirements the court identified, and 37 states currently have statutes that fit within those requirements. If you live in a state that you have always thought of as being fundamentally pro-gun, that does not mean your state government cannot and will not use the tool this ruling just validated. Check your state's specific statutes before you assume you are insulated from this.
The third and most dangerous version of the misinformation about this ruling is the claim that the Supreme Court just delivered a win for gun rights and that gun owners should be celebrating. Do not fall for that. The court upheld the legal framework that allows states to reclassify firearms. That is not a win for gun owners. That is a confirmation that a new regulatory tool is constitutionally available to state governments across the country. The fact that the court said states can do this within existing public safety law does not mean states should do it. And it absolutely does not mean this development is in the interest of people who value their right to keep and bear arms. Be very careful about voices that are framing this as good news, without explaining the mechanism of what the court actually authorized.
Here is what to watch for in the coming months and years, because this ruling is a beginning, not an ending. Within the next 6 months, expect state attorneys general in at least 15 states to begin the petition process for reclassifying firearms under the framework this ruling established. Some of those states are going to be ones that would surprise you. The legal tool exists now. Tools that exist get used.
Watch state legislatures over the next 2 years to see whether they move to expand the reclassification framework through legislative updates to their public safety statutes. or whether there is a significant pushback effort from pro-gun lawmakers to limit the application of the framework. Either outcome represents a major battleground for Second Amendment rights that is going to require informed, engaged gun owners to be paying attention. Multiple cases are already working their way through federal courts that will test the boundaries of the specific doctrines this ruling established. The parts lineage doctrine alone is going to generate substantial litigation, because defining what constitutes meaningful interchangeability with military weapons is a question that different federal judges are going to answer differently.
When different federal circuit courts reach different conclusions, those conflicts create the conditions for the Supreme Court to revisit the issue, potentially within 3 to 5 years. What we are witnessing right now is the beginning of a legal conversation about the scope of the Second Amendment in the modern era. And that conversation is going to play out over years and affect every gun owner in this country, regardless of what state they live in.
The people in this community, the people who are watching a video like this one, taking the time to understand what actually happened, rather than what the headline said, are the ones who are going to be positioned to respond intelligently and effectively when their state moves. Share this video with every gun owner you know who needs to hear this. The fight for your rights is not going to be won in a single court decision or a single piece of legislation. It is going to be won by people who stay informed, who understand what the law actually says, who know the difference between a classification and a ban, and who act on that knowledge rather than on emotion or misinformation. Subscribe, turn on the bell, and stay with this channel because we are going to cover every development in this story as it unfolds in courts and state capitals across the country. You deserve accurate information about your rights. That is exactly what this channel is here to provide.